All right. Good morning and welcome to this meeting on the Committee of the Revision of the Penal Code, which is now in session. I am Mike Romano, Committee Chair. Thank you, everyone, for joining us. I'm going to begin with the alphabetical roll call of committee members. Assembly Member El Hawari. She was here
Looks
a
like she just
second ago.
dropped off. Oh, here
Ah,
we go. She's back.
Assembly Member, you there?
She's probably still connecting.
All right. Well, we'll get back to her. Mary Kennedy.
Here.
Um, and I think we need to wait for the assembly members so we have a quorum. Assembly Member, you there? All right, Assembly Member, we can't, yeah, I think you're on mute or we can't hear you. We're going to wait. We need to wait until you sign on. Tom, in the meantime, will you ping Professor Ochin?
Sure.
And maybe the Assembly Member?
Well, I think we know she's
Mute.
she's
Oh,
here,
there
and
she,
I
oh,
think
Hi,
it's
I'm present.
yeah.
I couldn't hear anything. I don't know what happened, but I'm
you're
back.
back. You're
Sorry
back.
about that.
No worries, no worries. And we understand you'll come on Zoom in a moment. But let's get started. Um, This is our second meeting of the year, and we have three more planned. Today, we'll be discussing important sentencing elements, including aggravating factors, consecutive sentencing, Section 17B reductions, sentence enhancements, and more. Committee staff and researchers from the California Policy Lab will be presenting on these topics. We'll also hear from Tom about research and other updates from the April meeting, pending bills related to committee recommendations, crime data, and a few other updates. As always, we'll conclude with public comment. As we begin, a few reminders from the Bagley-Keene Open Meeting Act. Please note that members of the public can watch and participate in this meeting in the first floor conference room at 925 L Street if you would like to in Sacramento. And a reminder to committee members, unless you're having some technical difficulties, which the assembly member will say is now, please remain on screen as much as possible. All right. With that said, our topics today are common sentencing elements that are applied in thousands of cases in California every year. As we'll hear today, many of these sentencing issues, which include aggravating factors, consecutive sentencing, wobblers, lengthy sentencing enhancements, as I noted, they've undergone significant change in recent years. We'll explore how well the current framework holds together as a system as law has changed so much over the short period of time. Our discussion today will span some very technical procedural issues and scale out to bigger picture questions of whether certain sentencing policies truly improve public safety. So with that said, let's get started. In a break, I guess, from our usual format of stakeholder panels, today we'll hear mostly from Tom and Rick. They'll give us legal and policy background and explain their reform recommendations. We'll also hear from Joanna Laco. Is that how you pronounce your name?
Laco, yeah.
Laco, excuse me, from the California Policy Lab, who will be presenting data about sentencing enhancements. Committee members, because we're experimenting with a new format for these meetings, please jump in and ask questions and make comments during the presentations. Our goal is to have a good conversation and prioritize ideas and proposals for further work by staff. We are not voting today or formally endorsing any recommendations, but only identifying issues for our continued committee interest. Staff will focus our attention on specific proposals and details and report back to us throughout the year. And as we have done in years past, final recommendations will be made at the end of the years, and those recommendations will be published in our annual report, which usually comes out just after Thanksgiving. With that out of the way, Tom and Rick, take it away.
Great. All right. So I'll kick us off, and then we'll hear from Rick as well. So here's what we're going to cover. I mean, we've said it like 5 times already this morning, but just one more time. Aggravating factors in upper term sentencing, consecutive sentencing, which we'll move pretty quickly through, reductions under Penal Code 17B. So this is for wobbler offenses. A judge can reduce it from a felony into a misdemeanor. Enhancements, but in particular the nickel prior and the 10/20 life firearm enhancement. And at that point, we'll kick it over to Joanna to have a little bit more holistic data about enhancements. And we'll come back to Rick and myself talk about sentencing errors and unauthorized sentences and a court's ability to correct it in a small related issue. And we'll have staff recommendations for each of these issues throughout. So as Mike said, please interrupt. Questions are expected. If we don't get them, we'll feel like no one cares. Okay, so to start us off with the determinant, with the aggravating factors, I think a timeline is really helpful to sort of tell a story and explain where we are and how that has created some of the issues we think it's worth the committee to address. So we have about a 50-year history here, and it starts in 1977 with the determinate sentencing law. And this was the big change from indeterminate sentencing in California to determinate sentencing, where literally every felony offense, you'd be sentenced to life in prison, and then the parole board would decide when to let you out. So most people got out after a few years, but technically you were getting life, and the judge wasn't really picking the length of the sentence. That changed in 1977 when we created this triad sentencing structure, where there's now a low, a middle, and a high term for each offense. At the time, in 1977, there were 4 triads, and the high term was only 1 year higher than the middle term. So there wasn't a huge amount of swing between the middle and high term, at least as far as sort of years ago. Of course, going from 2 years to 3 years is a huge percentage increase in the sentence, but it was just typically 1 year. At the time the law passed, the middle term was the presumptive sentence, unless the court found aggravating or mitigating factors to increase or decrease from that middle term. And the Judicial Council was directed to develop what those aggravating and mitigating factors were. Fast forward about 30 years, and there was a big United States Supreme Court decision called Cunningham against California that was one in the line of these decisions around the Sixth Amendment right to a jury trial that had been percolating for a while by this point. And they said that the structure California had, where there's a presumptive middle term, but the judge could impose a higher sentence based on facts that the judge found, not the jury found, violated that Sixth Amendment right to a jury trial. And so the sentencing structure, that piece of it, was unconstitutional. The legislature almost immediately enacted a change to the law that eliminated that presumption for the middle term. So the court at that point had the ability to pick any term it wanted at its discretion. There was sort of no finger on the scale. Is that the metaphor for any one term in particular? And then that was the case for quite a while until 2022, when SB 567 went into effect. And it sort of went back to the original structure where the middle term, or actually it was the court couldn't go above the lower middle term unless the jury found the aggravating facts that justified the high term. So it wasn't actually a presumptive middle term. The court could pick the lower or the middle term, but couldn't do the higher term unless there were facts found by the jury that justified it. And then in 2025, there was a big California Supreme Court case that addressed an exception to this whole jury trial right. So there's always been an exception saying any fact that increases the sentence except for a prior conviction has to be found by a jury. And the California Supreme Court said that exception only applies to the fact of the conviction. So other qualitative things related to the prior conviction, like is the person's criminal history increasingly serious, which we'll see was a specific aggravating factor. You can't assume that just from the fact of the conviction itself. And if the person performed well on supervision, which is another aggravating factor, those actually have to be found by a jury. So because we've had different engagements by the Judicial Council, by the legislature, and, the Supreme Courts of, the 2 Supreme Courts that would deal with this, it just has left the law, I think, in an interesting place for us to pick up right now. But let's look and see, some data and what effect some of these policy changes had on ultimate sentence length. And I think we'll find doesn't look like it had too big of a change. So what this chart is here, and this was prepared by the California Policy Lab, but we just decided it made sense for us to do it. This is 20 years of sentence length for people who receive determinate sentences. So it excludes people who got life sentences, or life without parole sentences. So just folks who got determinate sentences, which is the most common sentence that type of sentence people receive in prison. And the blue line is the median sentence length, and the orangish line is the average sentence length. So the median of something is the number that's right in the middle. So if you look at, if you just line up all the sentence length, which number is right in the middle, and the average is, hopefully we all remember how to do an average, but that's a little bit more of a holistic way of determining, what a typical sentence looks like. We can see the median sentence length was about 2 years, and then this big jump comes at realignment when we got rid of a lot of those low-level offenses from going to prison. It increased the median sentence length, but of course, a lot fewer people were going to prison. And it's been 3 years basically since. So the Cunningham decision was right here in 2007, no change in the median sentence length. And then AB 567 was right around here. And again, no change. So these adjustments to court's ability to select the triad didn't really seem, at least, at this very rough glance, seem to have much change on the median sentence length. Average sentence length sort of tells a similar story. Average sentence is going to be higher because it's affected much more by some of those extremely long determinate sentence lengths, like 50 years, 100 years. But anyway, we see a sort of similar story where an increase after realignment, and then it basically holds steady until now. So, what I take away from this is that these changes and a court's discretion or ability to pick the high term seems like it didn't really ultimately have much effect on overall sentence length. Of course, that's just a very, first take on it. It's something we're going to continue to look at, but that's sort of to set the stage a little bit. Now, this is the actual distribution of triads in sentences for people who went to prison. So this blue bar is the percentage of sentences that receive the low term, orange is middle, darker blue is upper. So we'll see that the low term is the most common choice by far, across these 20 years of data. And the middle term follows about, so about half people get the low term, about a third get the middle term, and the remainder get the upper term. And again, so those big policy changes in 2007, sort of, in summer is when that decision came out. So if we look at 2008 and years past, we do see a little bit of an increase in upper terms, but, I wouldn't say it sort of jumps out a bunch. We see a bigger increase maybe with realignment, again, when we see less serious offenses no longer going to prison. And then the big change from the legislature went effect in 2022. And we do see, again, kind of a reduction from the year previous in the upper terms, but it looks a lot like it did before. And of course, COVID is happening there. So there's a lot it's hard to disentangle. And again, this is just what the triad term was. It doesn't account for sentencing enhancements or consecutive sentences or anything else that might affect the ultimate sentence length. But if we're looking at policies that changed how a court selects what the triad is, I think this is instructive to look at. And I was actually a little surprised that so many sentences were getting the low term. But here we are. Okay, and the last two slides on this are the data slides are looking at the percentage of determinate sentences by gender that receive an upper term. So again, we're going back 20 years. Let's just focus on the most recent years. So we have women on the left, roughly around 13% of determinate sentences for women are getting the upper term. It's a little bit higher for men, around 17%. So we do see a little bit of disparity in what percentage of sentences are getting the upper term.
Tom, since we're
Yeah.
talking about enhancements today, is there any correlation between getting the upper term and enhancements? Meaning, are they more likely to have enhancements if you have the upper term, or are people getting low term plus enhancements?
Well, you can't use the same thing for an enhancement in the upper term, but I think you're asking a bigger picture question. Like, is there sort of a way to use that to look at what offenses are sort of more serious than other offenses? And we looked at that a little bit, and I think we didn't see anything. I think we found it hard to describe that relationship, but it's something that's sort of on our research agenda to keep looking at.
All right.
All right, and here's a similar chart by demographics. So, this is race and ethnicity at the top. And again, let's just look at the most recent years, so 2023 to 2025. Let's just look at the Black versus white disparity to start off with. So this is the percentage of people in these groups with a determinate sentence for receiving the upper term. For Black people, it's been around, 17, 18%. For white people, it's a little bit lower, around, 16%. So compared to other disparities that we see and that we're going to see in some other data today, this, I think doesn't really jump off the page. And we see similar numbers for all the demographic groups here. But again, this is just looking at the triad selection for the primary offense. So there's sentencing enhancements and the other things that we do see more disparities around. All right, so that is the background on aggravating factors. And now I want to highlight some of the issues with the current framework that, this sort of different engagement by these different entities have left us. So we'll talk about procedural issues and substantive issues. The procedural issues is that even though the aggravating facts have to be found by a jury at a trial, there's no requirement that those facts have to be proven at a preliminary hearing, like the elements of an offense do. So preliminary hearing happens very early in a case. It's the defendant's first opportunity and a court's first opportunity to evaluate the evidence that the prosecution has. But these facts that can be really significant in deciding the ultimate punishment are not part of that proceeding. The other procedural issue worth highlighting is, as I just said, generally you can't use the same fact to justify the upper term and a sentencing enhancement, but that's not true for three strike sentences because courts have said three strikes is not an enhancement. It's something called an alternative sentencing scheme. And because of that, the statutory prohibition on dual use of facts for enhancements and upper term doesn't apply to three strikes because three strikes is not an enhancement. So what that means is someone who has a prior conviction, that conviction can be used to both give you the upper term and also to double your sentence as a second strike. And that just doesn't seem to be consistent with the general approach to these facts. Substantively, the aggravating factors, as we saw, were first drafted in the late 70s by the Judicial Council for use by judges who see, many, many cases. They're able to compare one case to another in their experience. And so they were written, and the Supreme Court has said this, they weren't drafted with jury findings in mind. They were drafted to sort of guide a judge's discretion. So they're a little bit more broader, written in a little bit more qualitative language. For example, if the offense involved great violence, I think a judge who's seen 100 cases involving violence can tell you what that is. A jury who's only ever going to be on, maybe one jury in their life, that's going to be a little bit harder. Again, if a victim was particularly vulnerable, very qualitative, if there was a great monetary value at stake, again, same problems. And also there's an aggravating factor that a defendant's prior convictions are numerous or of increasing seriousness. And again, I think that's a tough one for many jurors to be able to evaluate, given where they sort of are in the system. So a number of the aggravating factors are sort of a tough fit for this new structure we have where jurors are supposed to make these very specific findings. Then, of course, the jury finds the fact, but it's up to the judge ultimately to decide whether that justifies a higher term sentence. So it's this mixed role or sort of this, two-step process we have where juries now play an important part, but it's still ultimately the judge's decision. So it's not as if the judge isn't involved in how the aggravating factors are ultimately resolved. Okay, so here's our proposals. They won't sound surprising, but the first is to require pleading and preliminary hearings for aggravating factors like we do for the elements of an offense. So you would sort of have a little more consistency in how things that a jury ultimately has to find go through the system. The second is just to explicitly prohibit dual use of facts to impose both an upper term sentence and to allow a second or third strike. And the third is to direct the Judicial Council to revise the aggravating factors so that they are for better use by a jury. Now, the Judicial Council has said they don't want to do that. They think it's better for the legislature. But the reason I think, staff has concluded it makes sense for the Judicial Council to do that is they're the ones who've been doing it for 50 years. And the judges do ultimately have to decide whether those facts are what they want to use to increase a sentence. And, I think they have a particular expertise that would be useful here. So, the legislature can direct them to do it again, just like they did in 1976 with the original determinate sentencing law. Okay, that's aggravating factors. We'll move on to consecutive sentences. But any questions or
I just have
Yeah,
a question. Oh, I have just a quick question about judicial council. Just because I'm new here, is that the same judicial council as what we have at the legislature, or are you talking about a different body?
Yes, it's a different body, but of course they have the same name, so it's
Okay.
confused, or they have a similar name, so of course it's super
Yeah.
confusing. That's how lawyers like to do
Okay.
it. Just like there's a
Okay.
law revision commission to be distinct from the committee on revision of the penal code. So judicial council is sort of like the policy making branch of the courts. So they sort of
Okay.
make the court rules and forms. They do a tremendous amount of work.
Okay.
But it's the judges and legislative council are sort of the lawyers for the legislature. They play their role. So
That's helpful. Thank you.
distinct but similarly named.
Okay. Got it.
Yeah.
I have two questions. The first is, um, I'm a one-trick pony around three strikes, and the whole idea that the three strikes is a special sentencing scheme and not an enhancement comes up in lots of different contexts. Rather than just say like, okay, we'll prohibit dual use in three strikes context, can the legislature just say three strikes is a sentencing enhancement for all purposes, and that's what we intend,
Yes, I think
and just
yes.
do away with this idea of special sentence because it just is just cockamamie.
I yes, I think we'd have to really look at it, but I think that might take a two-thirds vote, whereas this change I think wouldn't. So I think it might be worth pursuing both. But I think that's a great approach.
Yeah, I'd be
And
curious about that two-thirds vote. I mean, there's nothing in the three strike statute that says it's a special sentencing whatchamadoodle. Like that's just court rules, right?
I think there might be other places in the law that address it. But we will have to look into it.
Okay.
But that's one caution I have. But that doesn't mean that you all shouldn't recommend it,
No,
obviously.
no, no, no. It's an
Yeah,
important caution. It just comes up a lot, and it just seems like I think
right,
a lot of our recommendations are try to just kind of make some sense out of all these disparate things, and that walk like a duck and talk like a duck, and we should just call them ducks. So the
right.
other is, and I was sort of also curious about Mary's take on this. If Judicial Council is so reluctant to do this, um, can we volunteer slash threaten to do it, and then maybe they would do it? I think that we would agree that probably the legislature is not an ideal place to hammer this out. But is that a possibility, Mary? I was wondering what your take is on that.
I sometimes they usually will end up doing this stuff you ask them to, even if they're reluctant. It just ends up being a big cost potentially. I don't know. They try not to get into policy. So it depends on how they define it, but that has changed over time. And just on the two-thirds, the take on anything touching three strikes has been really, really strict. So if it's anything that can be interpreted as narrowing it, Ledge Council is going to mark it two-thirds. So we have gotten around things that, such as like with the felony murder stuff, where we've been able to argue, but that was going back to the original ballot initiative stuff. I just think it's not that you can't be asked, but I just think you really have to have the arguments for why it's not against the initiative and kind of go deep on that because we've had those battles. So
Makes sense.
they tend to read them narrow.
And those battles continue, as I'm sure you won't be surprised to hear.
And sometimes it's the other way. There was at least one bill this year that people thought should have potentially been a two-thirds, and they marked it the other way. So nobody's infallible, but you do have to kind of have the arguments to be able to put them in a place where they can't disagree.
Sure.
And someone willing to do that. Those are the two. I'm just saying that I get very skeptical on the three strike stuff, but it's just because of the way it's been interpreted.
That makes perfect sense, and I appreciate that. I just think that people who don't like litigate this stuff every day are surprised to hear that the three strikes law is not an enhancement,
Right.
right? It doubles your sentence and it can give you a life sentence, but it's not an enhancement. They've decided to call it this other thing, and therefore it makes it immune from any rules about enhancements because it's not an enhancement. And that just seems like wordplay to me. I don't think it's in the initiative at all. This is just judges trying to keep longer sentences, honestly. So
Well, and Mike, on that point, the most recent case I think on this dual use thing about three strikes and aggravating factors, the defendant sought leave, and the California Supreme Court and three of the justices wrote a statement saying, yeah, this is silly, basically, the way we have these artificial distinctions. So I think it's if there's one more judge there to agree, the law could change and be a little more, I think, pragmatic and commonsensical. So it's not as if it's some off the wall argument. Three of them have basically said they agree with it.
I'm happy to
Well,
send my resume to whomever,
there's an opening, there's a vacancy,
I am not unaware.
So now you just will have to recuse yourself from this issue, from these statements. But anyway, so
I
we'll
have
look into that.
I just have a follow-up. Who made that initial decision? Was it the judges to make it kind of that separate, distinct? Like, is it judicial council? Just so I'm clear on kind of who makes those decisions.
It was judges. I'm not sure exactly, who was the typhoid mare, who was patient one, but
Okay.
yeah, it was completely judges, and it's created problems in many different types of circumstances. And
Yeah,
it's
Okay.
it's case law, but it has since then been adopted in different statutes by the legislature as well. So it's yeah. There
Okay,
isn't just
got it.
one place to cut it out from, unfortunately.
Thank you.
Okay, aggravating factors done. Let's go to consecutive sentencing. So, the general rule. So, consecutive sentencing. This is if you have two charges against you, and the question is, are you essentially going to get one sentence for them, or are you going to get two sentences, and you'll do one then the other? So, it's another way of the ultimate sentence being longer. And the general rule in California is that a consecutive sentence is going to be 1/3 the middle term. So again, you see this, the middle term did a lot of work with the original determinate sentencing law. So if your middle term is 3 years, your consecutive sentence for that would be 1 year. That's the general framework. There are some exceptions, the most significant, I think, involving 3 strikes, where there's sort of mandatory consecutive sentencing in some circumstances. But, we spent a lot of time looking at that, and it didn't seem right for the committee to engage with sort of the real core substance of consecutive sentencing. So we looked again at sort of the consistency with the procedural rules, and we think there is some work the committee might be able to do there. So even though a consecutive sentence can significantly increase someone's ultimate sentence, the amount of time they do, just like an aggravating factor can, there are different procedural rules that apply for consecutive sentencing. So nothing has to be proven to a jury, and nothing has to be proven at the preliminary hearing, of course, either, by that same token. And there's also, you're not limited just to the aggravating factors specified in the rules of court or other statutes. So it's a pretty wide open number of things that a court can consider. And this issue of does that itself satisfy the same Sixth Amendment problem, where we now are saying that any fact that increases a sentence has to be proven to a jury. In 2008, the U.S. Supreme Court said, no, that's different, because that's just the way it's always been. Sort of the reasoning put into a nutshell. But there was a dissent by Justice Scalia, and joined by the Chief Justice and Justice Thomas at the time. And they said, no, this is an artificial distinction. If it's a fact that increases punishment, it should all be subject to review by the jury, essentially. I mean, the exact sentencing scheme in Oregon was a little bit different, but I think that's a fair statement of the takeaway. And so basically, that's the staff recommendation, is that we should essentially take this Justice Scalia position and require any fact, including those that support a consecutive sentence, to be treated equally. The aggravating factors, consecutive sentencing factors should all have to be, part of the initial pleading, proven at the preliminary hearing, and found true by a jury. I think the ultimate decision, again, remains with the judge, but the facts that's basing that decision on should all be treated equally. So that's our consecutive sentencing take. All right. Now you get to hear from Rick about wobblers.
All right, moving on to Section 17B, reductions. This is a section of the Penal Code that's been in existence for quite a long time. It allows judges to reduce any wobbler offense that is charged as a felony to a misdemeanor based on their own discretion. And we in researching this issue, we found that actually there's a lot more wobbler offenses than we even expected, over 900. And that accounts for around 60% of all determinately sentenced offenses. And it includes many property crimes. So those are the type of offenses that we're talking about for 17B
And
reductions.
we're just talking, when you talk there's so many and it's 60%, that's just in the penal code, there are
Right.
900. It's not that there are 60% of everybody convicted of a crime as a wobbler crime.
Correct.
Got it.
Correct. There's a lot of wobbler offenses in the penal code, but that does not, as you said, we're not saying it's 60% of all people convicted and sentenced.
Gotcha.
And it's, you know, not this is super important, but it's every code. It's penal code, health and safety,
Right.
vehicle codes, which
Criminal
actually
law.
There's a
right,
lot of them
yeah,
in there. I get it.
right.
Yeah.
Well, judges, as you guys know, judges have very wide discretion in determining whether to exercise their judgment to reduce a case from a felony to a misdemeanor. Everything that they're supposed to be considered, that is supposed to be considered, has been kind of developed through case law that says they're supposed to consider things like the nature and circumstances of the offense, the defendant's background, public safety, rehabilitation concerns. They can't, use their power to reduce to a felony to avoid, some type of sentencing scheme like three strikes. But I think the general overview is that their discretion is very broad. There's nothing in statute that kind of guides it. It's all in case law, and even the case law leaves, a lot of leeway for judges to make this decision. This next slide shows the most frequent wobbler offenses over a 3-year period, and it shows the number of convictions and the percent that were misdemeanors. So as far as the type of cases, you see some, person offenses like domestic violence, assault, um, but you also see a lot of property crimes like theft, vehicle theft, vandalism, and some offenses are quite frequently charged as and convicted as misdemeanors, whereas others are very rarely. So you see things like a vehicle code section 2800.2, which is flight from police. That's only 7% of those cases are misdemeanor convictions, even though it's a wobbler, compared to, let's say, receiving stolen property over $950. Almost 60% of those convictions are misdemeanors. But however you cut it, it seems like there's a lot of room, for judges to exercise this discretion. A lot of offense in terms of the number of offenses, a lot of offenses that wind up as felonies that perhaps maybe could have been misdemeanors. Um, and that one other discrete issue we wanted to raise with the 17B reductions is that generally when a court decides to exercise their discretion and reduce a case from a felony to a misdemeanor, it is now a misdemeanor for all purposes. But there's at least one aspect that collateral consequences that court decisions have found that where people are unable to escape, and that's um, related to sex offenses and sex registration. There's a recent case that found that when a court reduces a felony sex offense to a misdemeanor, that doesn't require any re-tiering. California recently imposed this tiered sex offense registration system. So it's not all, it used to be across the board lifetime registration, but now there's different tiers based on the type of offense you're convicted of, whether it's a misdemeanor or a felony. And this case arose after that, where a felony conviction that required sex registration was later reduced to a misdemeanor. And the defendant said, well, can the court reduce my registration tier to what's appropriate based on this? And the court said, no, the initial felony is what controls. We have no power to reduce that.
Do we
And so
have any idea of how many sex offenses are reduced to misdemeanors? Like how many
No,
cases are we talking about? All right.
we aren't able to actually see when something is reduced from a felony to a misdemeanor. We can just see the ultimate conviction. It may have been charged as a misdemeanor in the first place.
Gotcha.
So we can't see that
Do you have
exercise of
any guess that
discretion.
this is a high volume, medium volume, or trickle?
I would expect a trickle.
Okay.
Tom, what do you think?
I you know better than me, Rick, but that seems right. You
Right.
see, you can imagine courts are going to be hesitant to reduce these types of offenses.
Right, on
Sure.
their own. I mean, this was
Sorry, maybe I'd ask it this way. How many sex offenses are misdemeanors, period, whether or not they were if there's only a small number of those, then we know that it is a trickle.
There's not a lot anymore.
That,
I mean, there's a few wobblers, but there's not a lot of misdemeanor, straight misdemeanor sex offenses.
right.
My guess too is the judge might be more reluctant to reduce it a misdemeanor and change, the fines and the jail time and those things. If the fact that the person already has to register is a bigger sentence. And so you take away the employment consequences and rental consequences, but they're still having to register. I don't know.
Right. I appreciate that there are a few number of cases in the penal code, but I want to know how many people are affected by this. Can we find out how many people have sex offense misdemeanors? Just
Yeah, I think so.
all right.
But
It
again,
depends
this
on
wouldn't.
unless it's ones that aren't registered, it'll be hard because if they're misdemeanors, they don't go to the state prison, which is easier to get the data for. But if they're registerable misdemeanors, then you should be able to get that data easily.
All right.
We'll take a look at
Is,
that.
Right.
is it also, I think the example that Rick shared, is it also possible to know if there's other examples or like how many times folks asking for it to be reduced to or adjusted in terms of the tier? I don't know how to capture that, but something to think about.
I don't know that we could see how, I don't think we could see how often folks are asking. I think we can look at felony wobbler sex offense convictions, the number of felony wobbler sex offense convictions. Now, all of those aren't going to get a 17B in the future, but that will show us like
Mm,
the pool of people that could potentially be eligible for a reduction. And I believe like some of the offenses that we're talking about are things like sexual battery, where like that could be a misdemeanor or a felony. I think in some cases, lewd conduct in public can be something
right.
that is a felony or a misdemeanor depending on the circumstances. So we can do more research on the specific offenses and number of convictions as felony offenses.
Yeah. All right. Should we keep moving?
Yeah, let's do it. All right, so the staff proposals here are there's three of them. The first is to create a presumption for misdemeanor reduction of property offenses. So this would presume that if you have a property wobbler, that the judge is going to reduce it to a misdemeanor. It doesn't, certainly wouldn't require judges to do it in all cases. And number two of this recommendation would be to develop factors for the court to consider that include things like the person's recent criminal history, maybe limited to a certain amount of time, and other collateral consequences of felony treatment, to put those things in statute to give judges more clear guidelines about how to exercise that discretion, similar to what the Penal Code Committee recommended with Penal Code Section 1385 and courts exercising their discretion to dismiss enhancements and the factors that were created to help guide that discretion. And then the third recommendation here would be to allow that reclassification when a wobbler sex offense in those extraordinary cases where the judge does decide to reduce a wobbler sex offense to a misdemeanor. In the case that we looked at, it was, post conviction, post judgment, the person had already completed probation, came back years later, asked the court to reduce it. In those instances, when the court does grant that reduction, they should be able to reclassify the sex registry tier in accordance with the conviction as a misdemeanor versus
Right.
keeping it as a felony.
In the spirit again of trying to bring some simplicity to this, can we just, instead of create new factors for 17B, can we say that the 1385 factors apply for every time the court's exercising its discretion in this sort of way? Just like,
I think a lot of those are not a good fit for this scenario. Like, if the sentence is going to be more than 20 years, or
sure,
if there's a gun that
that's
wasn't
infrequent in every case. I mean, but yes, but there's
right.
I think some of the
like,
things might cut across a number of different statutes, including like trauma, youth, being a victim of human trafficking. Those kind of cut across
criminal
multiple statutes
history.
that we would probably
Yeah, I
include
think there'll
those
be
as
some
well.
overlap. Yeah.
In other words, I would, if we can, I mean, in an ideal world, I think that there would be kind of a uniform list of factors that people use to rather than saying for 17B, we look at these factors, and for 13B5, we look at these factors. Just it's part and parcel of the same problem that I think we were talking about earlier in my head.
Okay.
Yeah. All right. Out of Wobbler Town.
All right. Moving on to Enhancement Town. We're going to talk about the nickel prior and the 1020 life enhancements. Um, Starting with the nickel prior, this is when a person is convicted of a serious felony and has a prior serious felony on the record. The court can impose an additional 5-year sentence and consecutive 5-year sentence for each prior serious felony offense. Recently, I think in 2018, SB 1393 allowed courts to dismiss these enhancements, and we are seeing them used less. But in kind of the extreme cases, and one aspect of the nickel prior is that um, for an indeterminate sentence, the same prior conviction can be added across multiple new cases. So, like if you have two new convictions, that one prior serious felony can add 5 years to each one of those new convictions. And so, what we see with the data is that for people who are sentenced indeterminately, who also have a nickel prior, their average sentence is 98 years.
And I
And
just want
one,
to also throw in there with about three strikers again. I'm one trick pony, but um, so not only do you get a life sentence because you have two prior strikes, but because those prior strikes need to be serious or violent, they're serious. That for every three striker, basically is not sentenced to 25 to life, but automatically 35 to life because the priors not only count to enhance their felony into a three strike sentence, but they also can get the nickel prior for each of the priors. So
Right.
it's like double or triple counting the priors, and it really drives the sentence. I mean, where the sentence for the initial crime might be 3 or 5 years, you're getting 35 to life because of the priors.
right.
It's a lot.
And it's added to an already indeterminate sentence, which is already long. And then at the time that this law was created, there was already on the books a 3-year enhancement that was available for violent offenses. That is still on the books, but it's not used because this one adds more time.
Right. Is there something that I was wondering if it's something we could do? I mean, it is crazy that you get more time for a prior violent offense than, I mean, for a prior serious
Mhm.
offense and less time for a prior violent offense. That just is cockamamie.
I don't think it works out that way because all of the violent offenses are also serious. So you could
No,
just
I'm just taking it
right,
statutorily.
Conceptually, yeah.
Conceptually, you're
right,
absolutely correct that
mhm,
they're so overlapping that everybody just chooses the nickel prior because
right,
gets the 5-year hit. But it just seems exact conceptually.
right. Another enhancement that's adding to extreme sentences is the 1020 life enhancement for use of a firearm. Now, this enhancement can only be applied to certain enumerated felonies and the really serious ones like murder and robbery. Um, but it adds 10 years for firearm use, personal use of a firearm, 20 years if you discharge it during the specific felony, and 25 to life sentence if it causes GBI or death if you hurt somebody with it. Um, Similarly, with the nickel prior and there already being on the books a 3-year enhancement, with this one there is already another enhancement available. It's a 3-5-10 enhancement for personal use of a firearm. It doesn't have these same distinctions of requiring, discharge or GBI, but there's a up to a 10-year enhancement available for using a firearm during any felony. And like the nickel prior, this enhancement, when it is added to sentences that are already long and just really compounds and lengthens the overall sentence length.
And
So a
Rick,
recommendation for each of these is to just repeal each of the nickel prior and the 1020 life gun enhancement. Interestingly, the nickel prior would require a 2/3 vote, but whereas the 1020 life enhancement would not. And like most of our committee recommendations, and the reasoning that, what's required now should be applied to people in the past. The recommendation here is to apply this relief retroactively as well.
I just want to say a couple things. First of all, in the gun use, Rick, can you give us some examples of the gun use? I think is not intuitive to people. Like the case law on use is pretty broad.
Yeah, for use, you don't have to actually, you don't have to shoot the gun. You have to kind of, the gun
Even
has to be, you have to use it as an assistance. So kind of like brandishing a weapon during a robbery
But
would
isn't it even if
qualify as
it
gun
not
use.
even not brandishing, even if nobody ever sees it, isn't hasn't court said that that's use because you feel more emboldened to commit the crime, even though you have it in your back pocket and nobody knows you have it in your back pocket?
That can be the case. I
There's
believe,
also
yeah.
the armed enhancement
Right. What's the difference
that's a
between?
different. I think that only adds 1 year, but that is very broad. Where like if you have the gun sort of available to you quickly, even if it's
For
not
Right.
on
offensive
you,
or
it can count as
defensive
being
use,
armed.
yeah.
Yeah.
What
So
But even
about
use is
even with personal use, I mean, like, hitting somebody with a gun,
right.
brandishing a gun, referencing a gun, in instances where the gun is inoperable, in instances where the victim can't, say with full certainty that it was a real gun or a toy gun. I
oh
mean, all
right,
those things can
do toy
qualify
guns
as use
count?
of a gun.
Do replica guns count?
Um, I'm not sure. I think it has to actually have the components of an operating firearm. So I don't
Okay.
know that a replica
Yeah.
gun would count.
I think the replica gun cases are not too numerous also. So
And do we know what other states do about, I mean, guns are obviously problematic and we don't want people to have guns. We want to deter it as much as possible. But do we know how enhancements go in other states?
it's I think they're much closer to the non 1020 life flavor that we have, where you can still add 10 years. That's pretty significant. We can look a little more closely at that, but turning it into a life sentence, I think, is relatively uncommon. But of course, those are very serious cases where someone is has been injured by use of a gun. So there's also other enhancements that California can apply there, like the great bodily injury enhancement. So there's many ways to, I think, address the extra harms, but we can take a look at other states as well.
And then the other comment I just wanted to make is like the idea of repealing this may seem somewhat dramatic, I think, but we know that the CDCR has really targeted these cases as ripe for resentencing, and thousands of cases, I think, right, Tom? I mean, well, many hundred have been sent back to courts by CDCR merely because the person has a nickel prior for resentencing. They've exercised their authority singling out these cases.
Right. And I think as we're about to see, there's a lot fewer people coming into prison with them as well.
Oh, good.
All right. Speaking of,
Right.
that's it, Rick. Right, Rick? We can
Mhm.
go over to Joanna now. Excellent.
All right. Can you guys see that?
Yep.
Yes.
Okay, great. So I'm Joanna Lako, Research Director at the California Policy Lab, UC Berkeley. Grateful to partner with you all on this work. I'm going to be talking about sentencing enhancements in the prison population. This is work with Thomas Sloan and L. Yang. So just a quick outline, I'm going to talk about overall enhancement trends, then get into gun enhancements, gang enhancements, and nickel prior enhancements, some of which you've already heard about, so I will try to keep my description quick. And all of this data is from CDCR, and I'll kind of walk you through what each figure is showing. So in these first few slides, I'm going to show you trends and how enhancements are being used in California over time. And I'm going to talk about two samples at first. So this is a sample of all admissions between 2014 and 2025. That gives you a sense of who's coming in the door to CDCR every year. And then I'm also going to talk in this first section about the currently incarcerated population as of March of 2026. That's a snapshot, like a point in time view of the prison population. and generally is comprised of people who were there for longer periods of time. So both give you viewpoints into the prison population that are important. Okay. So here is exactly kind of broken down by both of those two samples, and we're looking at the share of the prison population that has an enhancement on their case. And when you look at admissions between 2014 and 2025, you see that about 40% of people coming in the door have an enhancement on their case.
And just to clarify, 3 strikes is not an enhancement.
Right. Right. But this figure includes strikes.
Oh, it does include strikes.
This one includes strikes. There will be some that don't include strikes, and I will tell you which ones those are.
Okay, so for
Okay.
for this chart, at least 3
Yeah.
strikes is considered an enhancement,
Yes.
as it should. Go ahead.
Yes. Okay. Okay. So when we look at the currently incarcerated population, you see that 65% of people currently incarcerated as of March of 2026 have an enhancement or a strike on their case. Okay, so a much larger share in that currently incarcerated population, because those are the folks that are there for longer, have the longer sentences. Okay. So looking at the trends over time, we see in the total number of admissions with enhancements by a year, and again, this includes strikes, we see a decline leading up to COVID, right? So already the kind of number coming in the door is declining leading up to COVID. And then we see a more pronounced decline during the COVID period, and this really just mirrors the broader decline in admissions. And then we see a real flattening starting in 2021. So here we see each year about 10,000 admissions to CDCR with an enhancement or a strike. That's 2021 on. When we exclude strikes, the trend is really similar, right? So strikes make up a sizable share of what we're calling enhancements here. When we create this same figure without the strike enhancements, we see the same trends, but you see fewer than 5,000 admissions coming in the door with an enhancement starting 2021 on. Okay, so just a much lower number. So focusing on the most recent years, this is from 2020 to 2025, there is some variation in the share of admissions with enhancements by race and ethnicity. Here we're seeing the enhancement share is highest among people identified as Pacific Islanders and lowest among Asian people. Now keep in mind, there were only 122 admissions of people identifying as Pacific Islanders, very, very small, but we still see some variation across groups. And then when we look at the currently incarcerated population, the story is a little bit different. The enhancement share is highest among Black and American Indian, Alaskan Native people. So 76% of Black individuals who are currently incarcerated have an enhancement or a strike, compared to 57% of Asian people or 58% of white people. Second strikes are the most common. We see among the currently incarcerated population, 30% have a second strike. When you look at the kind of middle column, that's the most recent 5 years. It's about a quarter of all admissions come in the door with a second strike. Because we're talking, in this whole meeting about gun enhancements and nickel prior as well, you can kind of look down and see that about 20% of the currently incarcerated population has a enhancement for a firearm or a deadly weapon. About 15% has a 10/20 life firearm. That's the currently incarcerated population. If you look in the middle column again, in those most recent 5 years, the rates are pretty low of folks coming in the door with those enhancements. So only 1.5% of those people admitted between 2020 and 2025 have a 10/20 life firearm enhancement, for example. Similarly, with nickel prior, you see 12% of the currently incarcerated population, those are people that have those long sentences and they're there for a long time, and about 1.6% of people who have been admitted between 2020 and 2025 have a nickel prior. Okay, so next I'm going to talk about gun enhancements. So as was explained before, the person is convicted of a felony offense that involves a gun, they can receive an enhancement that adds additional years to their sentence. The penal code includes 18 separate gun enhancements. Until 2018, judges were legally required to apply the most common of these enhancements, including those with the longest additional sentences if they were charged by prosecutors. But SB 620, which went into effect in 2018, gave judges some more discretion in whether to apply several of them. So in these slides, I'm going to show you trends in gun enhancements before and after that policy change. And I just want to flag that we have a policy brief out today, live on the website, if you want to learn more about this. Okay, so gun enhancement admissions comprise 5.4% of all admissions in 2025, and the kind of last year of this graph. The number of admissions with gun enhancements has decreased by 24% since 2014, and that mirrors this broader decline of that top blue line of 30% decline in total prison admissions over that period. Okay, so the number is lower. You can't, it doesn't look like as dramatic a decline, but it's a 24% decline.
I have a question. I
Yeah.
don't know if you're gonna touch on this in your presentation, but giving judicial discretion, more judicial discretion around whether or not to add the gun enhancement, did judges stop using it as much because they realized it didn't really make a difference in like I guess I wonder, how did judges then decide? Was there just like data that showed that like adding all these years doesn't make a difference for folks, or just wondering like what kind of prompted that just like a change in like, I don't know, where we feel in terms of public safety too?
Yeah, I don't know if Tom or Rick could speak to this more about kind of what judges are actually doing. I mean, from my perspective, in the prior scheme, judges didn't really have a choice about whether to apply them if they were charged, a good number of these. So the question is, once you give some discretion and allow them to decide, what do they do? And that's kind of what we're trying to describe here. But it probably varies judge by judge quite a bit.
I just want to throw in here that applies to so many of our issues. Everything's confounded by plea agreements, actually, that we say that this is judges. But 90+% of these cases are by plea agreements, and not saying that enhancing judicial discretion doesn't impact the negotiation. It does in some way, especially if you're an economist. But I never know how to really account for that. Does anybody?
The
Thomas?
leverage,
Yeah, go ahead.
changing the leverage that one of these things provides certainly has an effect. And
Well, does it? I guess that's my question. It does in theory. Does
Could,
it actually in practice?
Mhm.
Yeah, it's an indirect effect because the sentences are not really the product of judicial discretion if there's a plea bargain,
Right.
but does the sense that if it was going to go to trial and get a purely judge-made sentence, would that be lower? Does that sort of depress the going rate for a particular offense? Well, I think we're about to see, it seems to have had some effect on overall severity of the gun enhancements that are still imposed.
Yeah.
So it seems like there's some evidence for that.
I also just, as we've all been talking about, there are a bunch of different kind of tools at the disposal here when we're thinking about sentencing that can make sentences long. So it's always a question for me, if you change, the criteria or the ability of the actors in this space to use one of them, they might just use a different one to achieve the same goal. So whether it has an overall effect on sentence length is, in all of the pieces put together, I think is the main question. And we'll try to get at that. I'll talk about it a little bit when we talk about nickel prior, where we're going to try to pull that apart a little bit better.
Okay.
But
and
this,
sorry,
yeah.
last question, apology. And just in terms of the data, is it possible at some point to like kind of break out the plea agreement versus judicial discretion, or is that too hard? I don't know how it works, so that's what I was wondering.
Yeah, we don't observe information on that in the state data. So not with the state data, but as we do more work locally, we're hoping to be able to have more insight into kind of the factors of plea agreements, but it's not something that we can always observe in the administrative data. Usually we have to go into kind of court comments and really try to pull that information out. Okay, so the average time added from a gun enhancement has declined since 2014. So it was 14 years in 2014. This is the dotted line. And on average, it's now 10 years in 2025. And then the top line shows you the total sentence on average for these same people, right? So the decline in the time added by the gun enhancement seems to translate into shorter average sentences in total. Although, as you can see, people admitted to prison with the gun enhancement are still serving very long sentences on average. So we're talking about an average of like 29 years at the end of this series. And then this is what Tom was referring to. So,
Oh, I'm sorry. Can you just go back one slide?
Yep.
I'm just remembering one of the earlier slides. How many people are we? How many people is this? So we know the average total sentence for people with guns is whatever, 20 plus years.
Yeah.
How
So
many
it's
people
about 1,100 people in 2025
per
were
year?
admitted
So
with a gun enhancement.
call it 1,000 people a year.
Yeah.
All right.
Okay, so the gun enhancements affected by SB 620 carried sentences ranging from 3 years to 10, 20 years, or even life. So during the past decade, when we look at the 12022.5A enhancements, and these are the ones that carry a 3, 4, or 10-year sentence, so this is the shortest of the enhancements that are affected by the policy change, those increased as a share of all gun enhancements from 40% in 2014 to 60% in 2025 of all people getting enhancements. So I know we're talking about plea deals, we're talking about discretion. There are different margins that you might observe change. It could be that not that they're not charging the enhancement altogether, but that they're selecting the shorter of the available enhancements, given some leeway in being able to do that. In contrast, you see the 12011.53 kind of B, C, and D. This is the 10, 20 years or life sentence decreased as a share of all admissions with gun enhancements from 41% to 29%. So those much longer enhancements comprise a smaller share of the total now. Okay. We see that Hispanic people comprise the majority of admissions with gun enhancements in both periods, so before the policy change and after, about 50%, and that Black individuals comprise about a little over a third. All right, I'm going to move to gang enhancements unless people have gun enhancement questions. Okay.
Oh, sorry.
Yeah, go ahead.
Do we have a comparison to the share of the population? Like how much Black folks are 34% here, but aren't we only like 9% of California 6?
Yeah, I think about 6%.
And then okay, thanks.
Mike, did you want to say something?
No, go ahead.
Okay. All right. So gang enhancements also add additional years to a prison sentence when a person's convicted of a felony offense committed for the benefit of, at the direction of, or in association with a criminal street gang. These enhancements were originally designed to impose harsher penalties on crimes that are associated with gang activity. But a policy change effective in 2022, so AB 333, narrowed the legal definition of a criminal street gang. It increased the evidentiary burden for prosecutors to prove involvement in the gang and granted judges greater discretion in the application of these enhancements. So in the slides that follow, I'm going to show you trends in the gang enhancement admissions before and after the policy change. All right, so gang enhancement admissions have declined by 89% since 2014, going from over 1,100 in 2014 to 132 in 2025,
Wow.
like very low. And you can see.
Yeah. So anybody have any idea I mean, I see AB 333, it may have helped, but
that decline is happening well before then.
I agree. So
Yeah.
What's going on?
And it's well before COVID too.
So I think the next slide, because the overall prison admissions have declined a lot. So that's a little bit of what we're seeing. But if you look at the percentage, which I think Joanna has next,
it's still a huge decline. I mean, they went from 3.1% of all admissions in 2014 to now it's less than 1%, right? It's 0.6% in 2025. So, I mean, the decline you see both in real numbers and in the share.
Any guesses? Rick, Tom?
No, I don't. I think it's, it was always a pretty small share of the admission population. Uh, and I think we're seeing, and certainly in more recent years, less violent crime. But there just seems to be less overall use. Though we have some county data I
Yeah.
think you'll find interesting, Mike, coming up too.
I don't know if I'm just speaking based like anecdotally, but I also feel like less like kids are joining gangs less, maybe too. Like so maybe that's helpful, especially because they're just home and not social as much. Like they're interesting in terms of like young people. So that could, but the fact that it's like 5 times less is really big.
Yeah.
Yeah. No, that's the smartphone explanation for everything. Since 2010, we see a lot of the youth risky behavior, as it's called, has declined significantly with, a rise in some mental health issues, I think too, but probably not unrelated. Well, the flip side of that is social media has actually made allegations, I think, of gang involvement a lot more numerous in some cases too, because you have a lot more, social media posts that law enforcement can
Easier to,
argue is gang related.
easier to prove.
Right. Perhaps.
And there are implications of having a gang enhancement beyond just the years added to your sentence, right? I think it can affect your placement when you're admitted. There are a lot of factors. So the fact that these are being used less, I think, has multiple effects. And another reason why it's important to think about is that it's one of the more disparate enhancements. So while we see disparities persist in who is getting gang enhancements, and this is just for 2023, 2024, and 2025, just want to highlight that all of these bars are under 1%. So the rates are low, but they're higher for Hispanic people and Black people than for white and people identifying as other race. And really, it's concentrated among young men in these groups.
I actually think that this graph even under dramatizes the racial disparities. I remember looking at this not that long ago, and it was like only 1% of all gang enhancements were assessed against white people in the Los Angeles County, something like that, of all the gang enhancements. Does that sound right, Joanna?
It's possible. Here, let me show you the county, some of the county information. All right, so this is showing the dark bar at the top is 2014 to 2019, and then the lighter blue bar is 2020 to 2025. So you can see the kind of the change over time by county. And, despite large declines, you still see that Merced and Tulare have the highest gang enhancement admission rates, around 3 and 4%, even in the most recent years when the overall rate is quite low. So you're seeing, counties have reduced the number of admissions by quite a lot, but there's still some variation in counties driving those admissions. We could do this by race ethnicity to get at your question, Mike, to see kind of where the disparities are largest.
Right. I guess the numbers that I was thinking is of all the people who get gang enhancements, which I understand is a smaller number and is getting smaller over time, that it's very infrequently applied against white people.
Yeah, of those 132, I think few are probably. I mean, it's not zero because it's here. This is the last 3 years, so
no, it's not.
But
zero.
it's small. Yeah.
It's almost, yeah. I just wanted to ask in terms of the county specific piece, I'm not as familiar with Merced and Tulare. Like, does that mean that those are like maybe more conservative, or does it just mean that more people are in gangs? Like, are they more like harsh, like in terms of their penalties and kind of assuming that folks are in gangs? Do we know? I just was wondering if you guys have any.
I'm not equipped to say, but definitely appears to be, it could be driven by kind of the underlying cases coming up and whether a gang enhancement is like appropriate. And it could be driven by, policy within the county about whether they're going to charge those or not, or if they're able to prove given the new higher bar of evidence. So I think there are a lot of factors.
But if you know, like Santa Barbara and Santa Clara are pretty high up that list, but San Diego and Riverside are near the bottom, which I think doesn't really break along the, you
Yeah.
know,
LA is
that
really
that
low.
approach.
Yeah.
Okay.
Do
Thank
we
Right.
you.
know, well, because LA drives everything virtually. Do we have any sense that the change of from Gascon to Hockman is going to change the numbers any dramatically? Do we have any preliminary data on that?
No, but it should. I mean, if the Gascon policies were being followed as written, and those are no longer in place, you'd expect to see an increase. But again, because so much of this is driven by plea bargains, and most offenses are so low level, where a lot of these enhancements are not really relevant, we'd have to be careful where we'd expect to see change happening.
Yeah. Okay, I'm going to go to nickel prior. So, as was discussed, since the 80s, courts have been able to add a 5-year enhancement for each prior serious felony conviction, regardless of when it occurred, called the nickel prior. SB 1393 in 2019 gave sentencing courts discretion to strike or dismiss the enhancements in the interest of justice. Prosecutors have to argue why that 5 years should stay rather than it being the default. And this is one way that it could potentially be a less effective bargaining tool as a result. And then SB 81, which went into effect January 1, 2022, created a presumption that judges should dismiss an enhancement if certain factors are met that we were discussing previously as well. So, for example, if a prior conviction is more than 5 years old, or if the enhancement would result in a sentence over 20 years. And this applies to enhancements beyond the nickel prior. But I'm going to show you in the next couple of slides trends in admissions with nickel and prior enhancements before and after both of these policy changes. So here you see that admissions with nickel prior enhancements dropped following both policy changes. So in 2018 and before, pretty consistently 4% up to 4.5% of admissions had a nickel prior enhancement. In 2019, it was 3.3%. And then, of course, COVID dropped everything, but still, stayed pretty low. And then after SB 81 went into effect, we see that consistently lower rate of admissions with nickel prior enhancements, around 1.5%.
Mary, I have a question for you. Do we have any sense about why 1393 and 81 were allowed to pass, even though nickel prior is a 2/3 vote?
I don't remember that discussion. I don't remember the 2/3 discussion, and it might be the I don't remember a discussion on that.
I think what happened was the nickel prior one, it was passed as part of Prop 8 in 1982. Judges could dismiss it. Then the legislature took that away. And then the legislature undid their taking away, if that makes sense. So the voter initiative.
That might be what it was, something more complicated than that.
Can you say that again, Tom?
So when Prop 8 passed in 1982, creating the nickel prior, it judges had the discretion then to dismiss it. The Prop 8 didn't address. But then the legislature took that discretion away. So it was entirely a legislative thing, the lack of discretion.
So we're just returning to the original initiative is the idea.
Yes.
I'll note here that we have a causal study underway to estimate the impact of SB 1393 on sentence length, racial and ethnic disparities, and subsequent contact with the justice system to get at this question of, did this policy change, holding everything else constant, like all of the other factors that contribute to an outcome like sentence length, make a difference?
And make a difference on prison population, not on public safety, correct?
We're going to look at subsequent contact with the justice system. So we'll look at recidivism after people are out as well as one view into public safety.
Okay, but also just in general, over this whole time horizon, crime is going down.
For sure.
Yeah.
Okay, so counties vary in their response to both policy changes. Here, the darker column is showing before SB 1393, so 2014 through 2018. The middle is the years between 1393 passing and SB 81, and then after SB 81. It's pretty interesting. These are just total numbers, right? Total admissions with the nickel prior enhancement for the top 15 counties by population. And you see, before the initial policy change, Los Angeles, Orange County, San Diego, and Riverside really driving admissions. After the policy change, everybody drops, right? Dramatically. And then it's also COVID, so, caveats up to wazoo. But then after SB 81, you see that, Los Angeles is sending fewer people to CDCR with a nickel prior enhancement than San Diego or Riverside, right? So there's been a pretty fundamental shift, it appears, in the activity at the county level.
But those are the Gascon years again.
Well, this is 2022 to 2026, so it's not all Gascon years.
Right.
And that's all I have. So happy to take any questions.
Super helpful. Thank you.
Joanna, Joanna, can you go back to like one of your initial slides? I can't remember exactly what it was. I wrote a note. It was like toward the beginning, maybe the second or third slide related to, I don't know if it was gun enhancement.
Guns?
It was showing black. Oh, it was that one, the Black and Native American slide.
This one?
Yeah. I was wondering, like the Racial Justice Act, I don't actually, I'm still like learning. Is there a world where we get to go back and look at like why enhancements are applied differently to racial groups, like given that we've done that? Like, was the Racial Justice Act looking at anything retroactively too? And is there an opportunity for us to kind of maybe say, well, if Black folks this was applied to them disproportionately, then we need to look back at everyone who got an enhancement between this time and this time. I'm just wondering if does like that require legislation or yeah.
Tom, you want to take this?
Yeah, the RJA is now retroactive, so folks in prison who think they have a claim can bring it. It is very individual specific, though, in some ways, where there isn't sort of a class action and you have to go in and show facts about your case. But a lot of those, if a lot of people are, I think, so in the same situation that, hopefully people won't have to sort of start from scratch in each individual case. And of course, you don't have a right to an attorney to start your RJA case.
But beyond that, and there has been zero RJA decisions finding that people's sentences are longer based on their race, even though the RJA has been in effect for over 5 years now. And I mean, it's just zero. It's really, so Tom is correct that the law does apply, but no cases have reached judgment on whether or not it does.
I don't know if this is the right time to ask this question, but is that like are people just worried that they're gonna like accuse their colleagues of being racist? Like what's the rationale behind not using the RJA given that like I don't know, even looking at these numbers that you could kind of tell that we've applied it disproportionately.
So we're working on this a lot at our Stanford project, and anybody else feel free to jump in. So first of all, we have heard anecdotally, and I'm trying to find out how much this is anecdotally, that there have been a lot of negotiated settlements when people threaten to bring the RJA and prosecution offices don't want to be found to be actually racist, that they're just settling cases a little bit quicker. That's very anecdotal. It making everybody feel better about the RJA in the light of the fact that, again, zero cases have reached resolution. The other is, and this is, that prosecution offices are extremely reluctant and have been fighting giving up the data that would be necessary in order to make out these claims and dragging their feet and throwing up every unbelievable obstacle, despite the fact that the legislature has repeatedly come back and sort of slapped down judges and courts and saying, we really mean it. We really mean what we said when we said give over the data. We're in the process of at least 25 cases litigating this throughout the state. It is a travesty, I think, and a great shame because I think the Racial Justice Act is something that California should be extraordinarily proud of, and its impact, again, in the anecdotal settlement cases which don't appear in the data, we just really don't know how widespread that is. If it is widespread, then I take everything I'm setting back. But I'm not convinced. And certainly in the retroactive aspect, I don't think a single person has walked out of prison or had their sentence reduced as a result of the Racial Justice Act. In this, and it's been on the books for 5 years. So anything you want to do to help make this
Yeah.
more effective, I am more than all ears.
And then is there an opportunity to collect data on what we're talking about in terms of the anecdotal, like, people are threatening to, and like, is that too hard to kind of connect dots?
I think that that is probably very difficult. We haven't even done, yeah, I think that that is very difficult to assess. I'm worried that as I repeat the idea that we've heard this anecdotally, that we're just kind of bouncing, everybody's saying this to each other. And um, I do know that there is a survey going around right now of practitioners who, I think by, I'm going to say UCLA Law School, but I may be mistaken, trying to get at some of this, I think. Um, Given the fact that there have been absolutely zero cases, I just can't believe that it's actually widespread. I don't know. Tom, do you have any insight on this or feelings about this? Or Rick or Joy or Joy?
Well, there's a number of folks working to sort of gather information about what's happening across the state, like the Office of the State Public Defender does that, and some other groups as well. But it's really hard, I think, especially in smaller counties that don't have like the RJA attorney at the public defender's office for like you even to know who to sort of ask at the office because the practice can often be so disparate. And I think it's really hard to know. And also the RGA was not pitched as, oh, this will help people negotiate better plea bargains. It was like, we will end racism in the criminal justice system. So even if it is helping defendants and their individual cases like that, that's obviously the defense attorney's only goal is to do that. But I think it's not really what the point of the RJ was. It was to have a little more, I think, transparency and to not resolve things kind of in secret. But we've had, multiple meetings about it, and I would love to talk to you in detail about the RJ as assembly member, as I'm sure Mike and others would as well. It's a very hard issue to figure out what to do next because I think there's been a bill every year, and I'm some people say that's actually slowing things down even more because the law changes every year, so we have to sort of reset some things, and I think it frustrates a lot of judges and other people who make decisions about this stuff. And then there's also the reality that for the statistics-based claims is really what we're talking about because there's also claims about racially biased language in court, and there's been a lot more decisions and some progress around that, though there is an issue pending at the California Supreme Court that could be a real setback for those cases as well, depending upon how it comes out. Um, the problem with statistics cases, and this is something we're working on with the California Policy Lab a little bit, is once you present something to a lawyer that has a decimal point in it that isn't a billing sheet or a percentage, their brain shuts off and no one wants to consider what it is. And I think there's a real resistance to understanding how to bring these claims, understanding how to oppose them if you're the prosecutor, whether you should oppose it, and then how to decide them if you're a judge. And I understand why that is, but it's a real culture shift, even aside from the explosive issue of feeling like you're being called a racist, which actually isn't what the RJ even requires, but that is, I think, how it feels to a lot of folks involved in these cases. So it's a real combination of a lot of very fraught issues, but it's something the committee has taken a lot of interest in. I think we'll continue to do so, obviously.
Yeah, you've touched a nerve with me. I just want to say a couple of things in reaction to what Tom said. First of all, there is another big problem with the small counties, is that there are not enough cases actually probably to make a legitimate Racial Justice Act claim, and that's going to be a problem because there are just too few cases to control for factors. I think that's going to require a legislative fix down the line. And then in the big counties, which Tom mentioned, that My understanding is that Los Angeles County has one attorney assigned to Racial Justice Act claims, and I will tell you from experience, they are asking for months and months and months of continuances because they're saying they're overworked, which they are because there's only one of them. It's our understanding. And I will just say, and I probably shouldn't in this forum, but I am particularly heated about it. As we've been talking this morning, a judge in Los Angeles County told my staff that they should be ashamed of what they're doing for bringing these claims. They said, um, there has to be a better way to be making a living.
Wow.
That's
Well,
awesome.
that presents some interesting litigation options going
Yeah.
forward. What to do with that statement?
That's a good
Um,
opportunity to call them racist. I'm just kidding. But one more question, actually, just really quickly for Joanna. It was when we're talking about gang enhancements, are those also able to be applied retroactively in terms of like,
mm,
or kind of looking back at gang enhancements because they were used so frequently and now they, we have opportunities for them to be used less, or I think it was the judicial discretion more. Is there an opportunity to go back, or is that not is that not legislation yet?
I can, Joanna, obviously, she'll jump in, but
I don't know.
so the actual change to Penal Code 186.22, which is the gang enhancement law that was AB 333 from Assemblymember, or maybe she was a senator, but I can't remember. It was from Kamlager. It was actually a Penal Code committee recommendation from when she was on the committee. That itself is not retroactive directly, but and I'd have to check the status of the case law. But if, like, for example, you're being prosecuted now as a second or third striker based on an offense that was a strike because it had an old gang enhancement, you could then challenge it then. And if you go back to court for resentencing for essentially any reason, they'd have to apply the current law to your gang enhancement, not the old one. So there are some at the edges it can be applied retroactively, but the law itself wasn't technically applied retroactively.
Thank you.
But you could bring an RJA claim based on the racial disparities that
Okay.
you believe are evident in your case, but that doesn't really have anything to do with the change in the substantive law.
And then
So
would it be
very
helpful to have
complicated.
would it be helpful to have legislation around that or not really?
Yes.
Beyond
Um,
600, Tom?
well, yeah, if you have a right to bring one or everyone has to be reviewed or sure. That's what we saw with the, another committee recommendation was to apply the repeal of another sentence enhancement. It was the 1 year for a prior prison term to apply that retroactively, and everyone who had it had to go back to court to be considered. And again, it was up to the judge with a strong presumption in favor of removing the enhancement. But I think we did a report with the California Policy Lab about outcomes from that, and that affected many people. Um,
It, as long as we're thinking this way, the big one that we've talked about today seems to be the one that's most applied most often is the nickel prior. Am I correct? Of all the
Well, it
enhancements.
depends how you think about it, because the nickel prior adds 5 years. 1020 life could add 20 years. So do you need 4 nickel priors to equal 1 20-year enhancement? Depends what is sort of the most important
I guess
thing.
I'm sorry. I'm sorry. I guess why I was focusing on the nickel priors is because the change in law has been rather dramatic in terms of the exercising of discretion. And CDCR has targeted a number of those cases to go back, perhaps as an opportunity for us to say those cases must go back for
Right.
to see if the judge wants to exercise their discretion.
Yeah. Well, that's why, I think the staff recommendation is repeal the nickel prior and apply that retroactively. Kind of just let's stop tinkering with the machinery of the nickel prior, to paraphrase another context. Because I think an interesting question is, I think a lot of people, nickel priors, have had a resentencing because of SB 43 to remove the 1 year as well, or some of these other opportunities. So if we're thinking more pragmatically about a more limited reform, do we say, okay, if you haven't had a resentencing in the last 5 years, that might be a way to narrow it? Because I think that might actually be a significant number of people. But that's why we're like, let's just get rid of it. It does not seem to help public safety. The discretion has shown that judges it does seem to be imposed less. Doesn't seem like it's unleashed a crime wave. And we have this other 3 year enhancement that's this is a recurring theme, but that was part of the original determinant sentencing law. There were 5 enhancements. That was one of them. There's a lot less violent offenses that were specified in the law when that passed. See our meeting last year about the explosive growth in that list as well. But that seemed like a good balance, and I think it also had a 5-year washout period. So that was sort of the approach taken then, and everyone said the determinant sentencing law was super harsh 50 years ago.
And I don't want to lose the idea that really we should be keeping our eye on public safety. And despite all these reforms, and despite the fact that California has reduced its prison population almost in half over the past decade, crime continues to tick downward.
Yeah, not just downward, but some of the lowest rates ever since we
Ever.
started keeping track in the 60s. So it's yeah,
And
it's
I think interestingly, and I think the FBI data just came out yesterday. Is that right, Tom, or the day before that is that
I'm not sure.
all right? Well, I think quite recently, but it's also down across the country.
Oh yes, that's for sure.
And what strikes me about that is that red states are down, blue states are down, almost identical amounts.
Right.
And so the idea that these policies are having dramatic impacts one way or another on public safety is I raises my eyebrow at you.
Right. Okay. Let's continue. Or should so we've got, I don't know, maybe half an hour-ish left. Should we take a break or just power through
Yeah, let's
or
take a
some other
5 minute
thing?
break, bathroom
Okay.
break, coffee break, whatever. Let's come back at 11:10. So that's a 7 minute break.
Okay.
Um, Thanks everyone, and yeah, see you in a few minutes.